We'll start now. Very firstly, very good morning, everyone. Myself, Trishita Pearl, working as a regional manager for Kenya region. I would like to thank everyone who have taken out their valuable time on a weekday and joined today's webinar on Kenya Data Protection Act 2019. So Kenya Data Protection Act was enacted in November 8, 2019 to regulate the processing of the personal data and to protect the privacy of the individuals. I would like to introduce today's speaker of today's webinar, Vikas Vedak. Vikas is an experienced practitioner in the field of cybersecurity, privacy, and data protection, working with network intelligence as a practice lead for strategy, risk, and advisory. He has over 20 years of experience working with customers in the Middle East, Africa, Australia, and India. Vikas has worked with multiple industry verticals and has successfully managed and delivered cybersecurity, privacy, and data protection programs to achieve the compliance with various national and industry standards, framework, acts and regulation, good practices, and guidelines. Now, I would like to invite Vikas to take it forward.
Thank you, Trishita. Good morning, all. Welcome to this brief introduction on the Data Protection Act 2019 of Kenya. So this is a brief agenda that we will cover during this webinar. Introduction, scope, exemptions, roles, responsibilities, principles of data protections, rights of data subject, collection of personal data, commercial use of personal data, data protection impact assessment, processing of personal data relating to children, processing of sensitive personal data, data protection by design and by default, breach notification, transfer of data beyond Kenya, penalties for non-compliance. This is a brief introduction about me, as Trishita has already explained. So I won't spend much more time onto this slide again, and let's move ahead. So the Data Protection Act 2019 falls under the, is an act of parliament to give effect to Article 31C and Clause D of the Constitution to establish the Office of the Data Protection Commissioner to make provisions for the regulation of processing of personal data, to provide for the rights of the data subjects and obligations of the data controllers and processors and connected purposes. It was enacted on November 8, 2019 to regulate the processing of personal data, to ensure that the processing of the personal data is guided by the principles set out under the Section 25 of the Act, to protect the privacy of the individual, to establish the legal and institutional mechanism to protect the personal data, to provide subjects with rights and remedies to protect their personal data from processing that is not by this Act. This is basically a very brief introduction. The most important, I feel, is that to understand, what are the principles and how the data processing is guided by those principles, and how, it affects to the individuals, the Kenyans, and the organizations who are operating in Kenya, outside Kenya, but are working with Kenyan citizens or holding data of Kenyan citizens. Now, this act applies to the processing of personal data. It says that it is entered in a record by data controller or processor by making use of automated or non-automated means by a controller or a data processor who is established or ordinarily resident in Kenya and processes personal data while in Kenya, or not established or ordinarily resident in Kenya, but processing personal data of data subjects is located in Kenya. So in short, this slide talks more about that if I'm providing any goods and services to Kenyan nationals, but my origin of the company is not Kenyan, but I do have the data of the Kenyans, then definitely this act is applicable to me and I have to work to ensure the compliance. And whoever, an organization who is collecting, storing, processing the data within Kenya is anyway applicable to this. What are the exemptions? There are general exemptions and exemptions by the data commissioner. It says that for general exemption, the processing of personal data is exempt from the provisions of the Data Protection Act if it relates to the processing of personal data by an individual in the course of purely personal or household activity. For example, if somebody is using somebody's name and address to send some greetings or certain goods and services on an individual basis or household as an household activity, maybe they will be exempted. If it is necessary for the national security or public interest, yes, it is exempted. And disclosure is required by or under any written law or by order of the court, then yes, it is exempted. So, many times we have seen that people first try and understand the exemptions before actually trying to understand what act is there. Yes, sometimes it's a good practice, sometimes it doesn't work always like that because if we go only by exemptions, then the compliance will always have certain challenges. Then exemption by data commissioner. The data commissioner may prescribe other instances where compliance with specific provisions of this act may be exempted. I think Office of the Data Protection Commissioner is already active, and you can visit their website to see more information and anything specific they publish on the exemptions from as per or under their mandate. This is a brief slide on the roles and responsibility, though it is explicitly explained in detail in the act document itself, the text itself. I'm just covering few which are more important, which I felt should be explained or should be understood. So first is the data commissioner, which is an established office mandated by this act, which is already up and running, and it has a definition saying that shall be a body cooperate with perpetual succession and a common. So these are the roles and responsibilities which says oversee the implementation of and be responsible for the enforcement of this act. Establish and maintain a register of data controllers and data processor. So if you go to the Office of the Data Protection website, you will see the process for registration of the data controllers and data processors. Exercise oversight on data processing operations. Yes, they have a mandate. Promote self-regulation among data controllers and data processors. Conduct an assessment on compliance. Receive and investigate any complaint by any person on infringement of the rights that the data subject rights, as we will cover in next few slides. Promote international cooperation. Undertake research on developments in data processing of personal data. Carry out inspections of public and private entities. Now, one of the good point in is a conduct on assessment on compliance. Yes, they have right to conduct an assessment on compliance. If you fall maybe a federal ministry or if you are a government entity, yes, they may conduct an assessment on compliance, or if they feel so, if there are any complaints raised by any individual saying that my data is being misused, yes, they may conduct. Next is a data controller. Now this data controller, I have covered both the definitions of data controller and data processor. The data controller is natural or legal person, public authority, agency or other body which alone or jointly with others determines the purpose and means of processing personal data. Data processor means a natural or legal person, public authority, agency or other body which processes personal data on behalf of the data controller. So data controller still remains accountable for every data process by the data processor. So the roles and responsibility, the data controller or data processor required to register under data controller data processor section 18 shall apply to the data commissioner, as I explained in my previous slide. Data controller or data processor who knowingly supplies any false or misleading details commits an offense. The data controller or data processor shall notify the data commissioner of a change in any particular outline under section 2. I mean, there is this particular subsection 2 where it says, in if there is any change, please inform them. Then data controller or data processor may designate or appoint a data protection officer on a determined terms and conditions. So many organizations these days who handle volumes of personal data, volumes of citizens data, they appoint a data protection officer. In short, they call it as a DPO, to ensure the compliance is maintained, sustained. The data controller or data processor shall publish the contact details of the data protection officer on the website and communicate them to the data commissioner. So some of this is my DPO at so and so company name, like abcd.co or gov.ke kind of a thing. I mean that is required. Next is a data subject. See, all of us, an individual, are data subjects under the Act. So data subject means an identified or identifiable natural person who is the subject of personal data. The Act designates certain right to data subjects that will be highlighted below, which I will cover in the next few slides. So any person, a living person, a natural person, is designated as a data subject. This is a data protection officer. A data protection officer may be a staff member of the data controller or data processor. And what is the role and responsibility? Advise the data controller, data processor, and their employees on data processing requirement provided under this Act or any other, written law. Like there could be certain other acts. For example, maybe some countries have ICT related acts or telecom related acts. So maybe those related acts also, how does they work in conjunction together with the data protection? Ensure on behalf of the data controller, data processor, this act is complied with. So DPO or data protection officer is also responsible to ensure and maintain the compliance with the act. Facilitate capacity building of staff involved in data processing operation. See, capacity building is also, making people or the staff aware of their responsibilities of data protection, how to handle sensitive and personal data, what to do in case of any data breach happens, what to, whom to complain, like how the data should be maintained, handled, processed, stored. Provide advice on data protection impact assessment and cooperate with data commissioner, any other authority on matters relating to data protection. When it says provide advice on data protection impact assessment, see, data protection impact assessment in certain uh, conditions, you need to conduct an impact assessment in case of the loss of this data. What are the impacts, regulatory impacts, financial penalties, and other things. So he is supposed to advise the organization, the data controller and data processor, like what are the data protection impact assessment consequences will be. Now these are the principles of data protection: data privacy, lawful, fair and transparent, purpose limitation, data minimization, accuracy, storage limitation. Personal data is collected only where a valid explanation is provided. Whenever information relating to family or private affairs is required, personal data is not transferred outside Kenya unless there is a proof of adequate data protection safeguards or consent from the data subject. So if you ask for the lawful, fair, and transparent, I feel that lawful is something that is important and falls under the law. Transparent, that the organization is very transparent, saying that what they are going to do with your data. It is published on their privacy policy and their website, saying that what do they do with your data, under what conditions, and why they are collecting your data. And in the privacy policy, they will also share what purpose limitation they are collecting for. and the minimum data they required from your side, to process them, store them, utilize them. And accuracy is, uh, only the accurate data is collected. What is required, what is the purpose, what is fair and falls under the lawful requirements. When you say storage limitations, in like most many organizations, you will see they have this data retention policies. So storage limitation and purpose limitation goes hand in hand. The data minimization also, so that I'm only storing the data what is required to the limit and the purpose I'm supposed to maintain and keep. And I will not basically store that data once my purpose is no more or no longer is required. And I'll maintain only the accurate data. The personal data is collected only where the valid explanation is provided. Like uh, in simple word, I can say consent. The consent is taken and your data is collected where the valid explanation is given before your consent is taken. See why we are collecting your data, what we are supposed to do with your data, and it is transferred outside Kenya cross border where there's a proof of adequate data protection safeguards or consent for the data subject that yes, you can share my data outside Kenya. So these are the principles of data protection. Generally, uh, most of the data protection acts worldwide they have certain principles. So these are the principles. So like data privacy is, I would say privacy is everybody's right. So let's talk only on the privacy, saying that is privacy is important for every individual. So privacy is not important. Now, what are the rights of the data subject? Now, if you look at the rights of the data subject, I will go clockwise just for the benefit of all. So right to be informed is that, on the website privacy, the right to be informed is there. Even at the collection of the data, processing of the data, they have a right to be informed how they are going to use your or my data. They will have a right to access in the sense that in case if I'm a Kenyan citizen and I want to connect, saying that okay, I want to access my data, what you collected, show me what you have written. Maybe you have spelled my spelling or my name not correctly or my address is not correct. So you should give access. They should have a right to access their data. Right to object to processing, like at the time of consent, sometimes some organization they say okay, do you want us to also share uh, you know this data for processing purpose, like for marketing purpose or mailing purpose or anything. So they can deny that, saying that yes, you can collect my data but you cannot actually utilize for any other purposes. Then right not to be subject to automated decision making. It means that by automation, I don't want to receive any mails or any marketing campaign without my consent. So there is no automated decision making because my last spend in the supermarket was XYZ. I should be a targeted one, sort of that. Then right to erasure, is like I no longer want to be on your database. I can write to the DPO or to the a person who is the SPOC for that organization, saying that please erase my name and my personal details from your database and send me an acknowledgement that it has been deleted. Right to data portability is like I'm moving from X to Y kind of a thing. So I kindly port my data to so and so company also. Right to rectification is and right to access goes hand in hand sometimes. Like right to rectification, I want to rectify my data. You did not put the PIN code correctly or the telephone number is incorrect. I have a right to rectify my data, verify my data. So these are 6 or 7 rights that every data subject has under the act, and these are very important rights, and this is what the beauty of the data protection, and that it gives an individual the right as long as they are aware of their rights. And when we talked about the data processor, data controllers, their staff should also know, like when they receive such uh, request, data subject right request, how to handle them, how to maintain the record, and the communication between them. Now, collection of personal data. The collection of personal data is generally either data controller or data processor shall collect personal data directly from the data subject. For example, many organizations all over the world, they provide you sort of a loyalty card and they collect your names and address and details, your emails, your phone numbers and all. So they are collecting. And basically if they are collecting, then they are either data controller or data processor. And despite subsection 1 above, personal data may be collected indirectly, like data is contained in a public record, telephone directory, for example. Data subject has deliberately made the data public, LinkedIn, for example, Facebook. The data subject has consented to the collection from another source, like they have some arrangement with another data service provider or data source. The data subject has an incapacity, the guardian appointed has consented to the collection from another source. The collection from another source would not prejudice the interest of the data subject. The collection of data from another source is necessary either for the prevention, detection, investigation, prosecution, and punishment of crime, for the enforcement of a law which imposes a pecuniary penalty, or for the protection of the interest of the data subject or another person. So this is very, very legal terminology. A data controller or data processor shall collect, store, or use personal data for a lawful, specific, and explicit defined purpose. This is the most important thing. As long as collected directly or indirectly, you are giving consent and you are understanding for the purpose you are sharing your data with them. Then this is, the data controller, data processor are actually doing because you are providing consent. It is not automated. Consent is already ticked. Now, commercial use of data. The person shall not use for commercial purposes personal data obtained pursuant to the provisions of this act unless the person has sought and obtained the express consent from a data subject, like as I said, for the marketing purpose, or sharing with their other subsidiary organizations or whatever. Is authorized to do so under any written law, and the data subject has been informed of such use when collecting the data from the data subject. So when a lot of times when you sign any consent form, please read what is written there in that fine print. A data controller or data processor that uses personal data for commercial purpose shall, where possible, anonymize the data in such a manner as to ensure that the data subject is no longer identified. So this is the most important thing, you need to anonymize the data so that the data subject is no longer identified directly. The Cabinet Secretary, in consultation with the Data Commissioner, may prescribe practice guidelines for the commercial use of personal data in accordance with this Act. So far we have covered basic things, the roles and responsibilities. We have covered the data subject rights. We have covered what is personal data, data controller, data processors, data commissioners, and the principles, data protection principles. So before I move, if any questions or queries. Okay, there was one particular query saying that what qualifies as a personal information. So my question is, any personal data like name, address, phone number, which is tagged to you or which is linked to you, or even your citizen ID or national ID, which has your number and all the biometric information, can be termed as personal data or personal information. In some standards, it is also called as personally identifiable information (PII) data. So I'm moving to the next slide. Data protection impact assessment. So very, very important step for a DPO and for a data controller. And now DPI would apply to any processing that by its nature, scope, context, purpose would result in a high risk to the rights and freedoms of the data subjects. So when I say risk to the rights, we already saw the data subject rights, 6 or 7 of those rights, and freedoms of the data subject. Anything which the data controller feels will have a high risk. Then the data protection impact assessment should be considered. The general regulations identify that the DPIA or the data protection impact assessment is required in a high risk activities, including automated decision making with legal or significant impact, processing of biometric or generic data. Processing prevents the data subject from exercising their data subject rights. Systematic systematic monitoring of a publicly accessible area. I mean, many times you will see in a parking zones, you will see a CCTV cameras, or in a traffic lights, you will see a CCTV cameras. Then, or some organizations also use of personal data on a large scale for purposes other than the original reason for collection. The purpose limitation principle, if you remember, or lawful, fair, and transparent principle. Then where there is a change in any aspect of processing, that may result in a higher risk to data subjects. Processing of sensitive data, data relating to children and vulnerable groups, and financial reputational benefits, demonstrating accountability and building trust and engagement with data subjects. So these are some of the high risk activities. If they fall, those criteria are met, then the data protection impact assessment. Once you start doing the risk assessment, so it actually gives you a lot of insights, and that because your ultimate goal is to to prevent or to stop the fines from happening. Is my audio clear now? Is my audio clear?
Yes, Vikas, it's clear now.
Processing of personal data related or relating to children or child. So every data controller and data processor shall not process personal data relating to child unless a consent is given by child's parent or guardian. The processing is in such a manner that protects and advances the rights and best interests of the child. A data controller, a data processor shall incorporate appropriate mechanisms for age verification and consent in order to process the personal data of a child. This is very, very important in all data protection acts world over. As a data controller, a data processor, you need to be very careful what kind of a data you get. So when you are doing data inventory, ensure that the children related data is not covered at the time of processing. Processing of sensitive personal data. No category of sensitive personal data shall be processed unless principles of data protection apply to that processing. So there are 8 data protection principles will be applied and they will check whether this particular data falls under sensitive or ordinary data or normal data. Without prejudice to the section above, sensitive personal data of a data subject may be processed where the processing is carried out in the course of legitimate activities with appropriate safeguards, with a political, philosophical, religious, or trade union aim, and on the condition that the processing relates solely to the members of the body or to the persons who have regular contact with it in conjunction with the purposes, and the personal data is not disclosed outside that body without the consent of the data subject. So in short, what they are saying is here that the legitimate activity, if it is there, and appropriate safeguards is like preventing this, and safeguards are also sort of a technical and organizational measures are taken appropriately, then yes, the processing relates to personal data which is manifestly made public by the data subject. Processing is necessary by the establishment, exercise, or defense of a legal claim. The purpose of carrying out the obligation and exercising specific rights of the controller or the data subject, or protecting the vital interests of the data subject or controller, another person where the data subject is physically or legally incapable of giving consent. So when the last line is like they are not able to giving consent, maybe for senior citizens or or handicapped persons or any person who is physically or legally incapable of giving consent. Now, data protection by design or default. Every data controller, processor shall implement appropriate technical and organizational measures which are designed to implement the data protection principles in an effective manner. Those data protection principles we saw: data privacy, lawful, fair, and transparent. You have data minimization, purpose limitation, accuracy, all those 7, 8 data principles. To integrate necessary safeguards for that purpose into the processing. The duty under the above section applies both at the time of determination of the means of processing of the data and at time of processing of the data. So when you are doing a taking a data inventory, though it's consentful, you are saying that okay, what kind of a data protection by design and default I have applied at the time of collection, at the time of processing, at the time of storage, at the time of publishing those data or sharing those data, or when I'm even answering the data subject access request or any data subject rights request. The data controller or data processor shall implement measures for ensuring that by default only personal data which is necessary for each specific purpose is processed. So that's the principle of purpose limitation is fully followed, lawfulness is followed, fair and transparent is followed. Notification and communication of a breach. Now, if you look at in case of a breach, a data controller shall notify data commissioner without a delay within 72 hours of becoming aware of such breach and communicate to the data subject in writing with a reasonably practical period unless the identity of the data subject cannot be established. If you go on to the office of the data protection of Kenya, there's a website and there's a particular section, I think in under services, I'm not so sure, or e-services. There is something called report data breach guidelines on reporting data breach, and the form will open. That form actually, if you see, is very, very comprehensive, very well written. And under the drop down also, you can choose what kind of data according to you or according to the current investigation that you are doing falls under. And in case of a data delayed or beyond 72 hours of breach notification, the notification shall be accompanied by reasons for the delay. Why there was a delay in justifying. If the data officer becomes aware of the breach, he should notify the data controller within 48 hours of becoming aware of such breach. So, notification and communication of breach is very, very important. But the most important thing is determining it is actually a data breach. So the data protection officer, his team, and with data controller and other staff data processors, they need to really determine is that a real data breach before I go ahead and inform and notify my people and to the office of the data protection commissioner, also uh, to the to the data subjects according to their rights they need to be informed. Now, transfer of personal data beyond Kenya. A data controller or data processor may transfer personal data to another country only where the proof has been given to the data commissioner on the appropriate safeguards with respect to the security and protection of the personal data. Like in GDPR, if you know GDPR, there is an adequacy principle where they follow this that the other country will also have under the EU also will have an adequacy or adequate safeguards to security and protection of the personal data. Proof has been given to the data commissioner of the appropriate safeguards, including jurisdictions with commensurate data protection laws, like other countries' data protection laws where the data is going to get transferred. The transfer is necessary for the performance of the contract between the data subject and data controller or data processor or implementation of pre-contractual measures taken of the data subject's request. For the conclusion or performance of a contract concluded in the interest of the data subject between the controller and another person for any matter of the public interest, for the establishment, exercise, or defense of a legal claim in order to protect the vital interest of the data subject or of other persons where the data subject is physically or legally incapable of giving consent. For the purpose of compelling legitimate interest pursued by the data controller or data processor which are not overridden by the interests, rights, and freedoms of the data subject. So, uh, they call it as a in some data protection law. There's a terminology called cross-border data transfer. So, these are some of the criteria under the data protection act of Kenya. And there is a terminology called binding corporate BCR. They call. Okay, certain companies they have a BCR which they publish accordingly, and they provide the necessary proof to the local authorities. Now, the notices is where the data commissioner is satisfied that the person has failed or is failing to comply with any provisions of that. That's an enforcement notice. The data commissioner may serve an enforcement notice on a person requiring that person to take such steps and within such period has been specified in the notice. So if you remember the roles and responsibility of the Office of the Data Protection Commissioner, there was one particular line says that, checks on compliance, conduct and assessment, compliance assessment or something. Then penalty notices are, in if the data commissioner is satisfied that the person has failed, is failing as described in section 58 enforcement notice, the data commissioner may issue a penalty notice requiring the person to pay to the office data commissioner an amount specified in the notice. So that is the penalties or the fines. Now, penalty for non-compliance. Like if you really read general penalty, a person who commits an offence under this act for which no specific penalty is provided, or is otherwise contravenes this act shall, on conviction, be liable to a fine not exceeding 3 million Indian shillings or to an imprisonment term not exceeding 10 years or more. The administrative fines in relation to an infringement of a provision of this act, the maximum amount of penalty that may be imposed by the data commissioner in a penalty notice is up to 5 million Indian shillings, or in the case of an undertaking, up to 1% of the annual turnover of that particular organization or the preceding financial year, whichever is lower. So there was one particular question, was query was there that please provide examples of automated decision making with legal or other significant defect. What we have seen is that many times when you are actually going onto a particular website and you want to download some information, which is maybe a report or something, and if they do not give you a consent sign, like they do not provide saying that please provide a permission to send our so and so brochures or XYZ, and it is automatically already ticked. It's one of the example of automated decision making, that if there is a consent that check box is there where a user or a person is actually checking that box, tick marking it, or using it, then it's not an automated decision making. So with this, I conclude this brief seminar on the data protection of Kenya 2019. I hope it was useful to you. If there are any specific questions or clarifications, I would be happy to answer.
Thank you so much, Vikas. Thank you for your wonderful presentation. It was indeed very useful. I hope the participants also felt this information very useful. So just wanted to invite for more questions. If you are having, we'll be very happy to clarify it.
If there are no questions, then we can conclude this webinar. And I wanted to thank all of you who took your time and attended this webinar. I hope it was useful, and we'll be happy to assist, provide services to you.
Thank you so much. Thank you very much for attending this.